Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer podcast. I'm Thomas Vick of Vick Law PC, and I'm joined as always by Seth Wilson of Adler Attorneys in Noblesville, Indiana. And we're here for another discussion of the blog posts on the Vick Law website. Seth, how are you today? And what do we have on tap?
Hey Thomas, good to see you. I'm doing great and enjoying, heading into spring break time around here in
Sure
our
feels like
world.
it. Spring break time, 45 degrees and rainy.
That's right. That's right. We had a mild winter and now we're having a cool spring. I'm not sure what's going on here, but what do they say about life in Indiana? If you don't like the weather, wait 5 minutes.
That's right.
So that's a good thing. Hey, I thought one of the topics that kind of caught my attention today and really in kind of recent days of discussions with clients is the idea of beneficiary designated accounts and kind of how that works in connection with your estate plan. So how do you typically talk about a policy beneficiary designation? Maybe it's on a life insurance policy, for example.
Yeah, so when there is an account or an insurance policy that names, and we'll just talk about life insurance for a little bit here. When you have a beneficiary of a life insurance policy, your beneficiary designation of that policy supersedes whatever you have in your will. And so you need to make sure that there's consistency in your life insurance beneficiary designations and your will, and make sure that your will isn't causing confusion with what the person that you've named as beneficiary of the life insurance policy. So that's the kind of the legal 30,000-foot view. You need to have that, but there can be some confusion if, for instance, an individual puts down in their will that the life insurance policy is to go to son A, but then the life insurance policy actually says that it's to go to son B. Son B is actually going to get that rather than son A, even though the will says that. And so it's just important that you don't cause confusion and you understand the rules that are involved in naming a beneficiary designation.
Yeah, I think the other area I see this sometimes play out is if, for example, the client says, hey, I want to give a specific monetary gift to this beneficiary. And I think sometimes there's a thought, okay, I have sort of my estate and it equals $100,000, just as an example. And I want $10,000 to go here and $5,000 to go here. I always have to ask that follow-up question of when the rubber meets the road, where are these funds coming from? Is that coming from a checking account? Is it coming from a savings account? And what you'll find sometimes is that, oh, well, I have a life insurance policy that is going to cover these designations. And that then will trigger, hey, let's review the beneficiary designations that you do have and make sure that that works in conjunction with what you really want to do here. And obviously there's some other technical things you want to think about in terms of tax issues and stuff if we're talking about other types of beneficiary designated accounts, which is always a good thing to discuss with the attorney as you're looking for that. But general rule of law is that if it's beneficiary designated, that document is its own estate plan between you and the manager of that company, and your will not get carried out in that sense. So you want to make sure that everything kind of works in connection. And a related topic, Thomas, is the opportunities in some type of accounts to add a payable on death or a transfer on death designation to those accounts. And how do you see that in your practice?
Yeah, I think it's a good idea. My personal opinion is it's a step below having a revocable trust. But having transfer on death beneficiary designations can be a really nice and efficient way of passing wealth from one generation to the next. And again, it might be that you name a specific transfer on death beneficiary, and that designation is different than what you have in the will. It's a pretty common thing for a client to say, well, I'm just going to give everything to this child, and this child is going to distribute it among the other children, or the other one. That person knows my wishes, and they'll make sure that my wishes are honored. Well, that may be true, but it may be very difficult for that child to make distribution in a legal way without having to file tax returns, gift tax returns. And from a legal standpoint, you don't know if that person is, they're not obligated to do anything. So they may honor your wishes, or legally they don't have to. And so it's, again, you don't want to cause confusion with a difference in your beneficiary designations versus your will. So general rule, beneficiary designations are, they're going to override your last will and testament. But Seth, does that mean I don't need to have a last will and testament?
Yeah, well, we're lawyers, so the answer to that is always no.
Right.
Or I guess a more accurate answer would be it depends. But
Yeah.
my general advice would be no. You still need that document in place, and having that estate plan just mainly to prevent that confusion from happening, and from the default rules of intestate succession coming into play and potentially muddying the plan even further, and create some challenges for your intended beneficiaries as you go. And I really like the point that you brought up on the sort of the joint account payable on death, transfer on death designations. A lot of these have been established as a way to be helpful for folks, and that's great. But there's always sort of the next step in the analysis, which is the law of unintended consequences. So if you leave a joint owner with a significant account balance, and they are responsible to distribute those funds among the kids equally, that puts them in a unique situation of having to use their gift exclusion every year, or use up a lifetime claim, and by filing a gift tax return, which could have all been avoided had there been another plan in place, because you can pass most of those things without any type of inheritance tax issues through proper planning. So you need that will in place to make sure that your wishes are carried out, and also provide that map for the personal representative to follow as to how you wanted things to go. And then the policy, obviously, beneficiary designations or the transfer on death, things that can happen automatically, really do work hand in glove to help move your assets appropriately and how you desired, with the least amount of impact possible on the beneficiaries.
All good stuff, Seth. Well, why don't we take a minute here and talk about some changes to the Lifetime Legacy Lawyer podcast. Most of the time we have had a live stream on Facebook with the video. That's what we're doing right now. But Seth, why don't you tell the audience what changes are coming for the Lifetime Legacy Lawyer podcast?
Well, we are always seeking to get better and deliver the right material, and also then kind of have an archive of frequently asked questions, if you will. So if we've talked about a topic that you may want to share with somebody else that would be interesting, try to make that easier. So we're going to move some of our content and production over to YouTube. We have created a channel over there that you can subscribe to and get updates when we post a new video up. We will still then probably bring that content from YouTube over to Facebook and those types of things, so you have access to it. And we also have the capability to pull an audio podcast as well. And so trying to get the same kind of content and material out for folks, just to help really with that educational piece of good questions to think about as you're considering your estate plan. And so you may see some more requests from us to help us share the word, if you will, by subscribing to that content and enabling us to get that out to you a little bit more easily and hopefully more consistently as time goes on.
And also another announcement is next week, we expect to have a guest with us. Teddy Kahn, who is a realtor that I have worked with on an estate administration issue. He's going to join us and talk about his experience with dealing with real estate that is involved in some kind of estate matter, and how he's seen that worked out, and kind of see what his perspective is as a realtor. We have our own perspective as attorneys, but realtors are often involved in these situations, and they have their own thoughts on the matter. So that'll be enjoyable, I hope, for the audience to listen to, and hopefully we have a good back and forth with Mr. Khan next week.
Yeah, I'm really looking forward to that. I think it's gonna be a lot of fun. And again, it just kind of underscores the importance of having that good team of professionals around you as you navigate some of these issues. And the more trusted advisors you have kind of advising through a situation, the better result you're going to get as part of that. And great to have resources like him coming on and sharing his knowledge and experience with our audience.
All right. Well, Seth, tell everybody where they can find you.
Hey, appreciate that. We're up in the heart of Hamilton County in Noblesville, Indiana, and you can find our contact information at the website, noblesvilleattorney.com. How about yourself, Thomas?
And people can find me at viclaw.org, and you can sign up for an appointment on viclaw.org, or just give us a call, and we'd be glad to help you out. We'll see everybody next time. Thanks for tuning in.
Thanks, Thomas.